Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding, we thine unworthy servants here gathered together in thy name do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that we, having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This Honourable Senate for Friday, June the 5th, 2020 is called to order and resumes its sittings. And before we get into the business of the day, just wish to bring to the attention of the Senate and to place on the record of this Honourable Senate the fact that one of our number has received a most deserved award and recognition, and as usual we share in the good fortune of all of our members. I speak to the award, the University of the West Indies Vice Chancellor's Award for Excellence in the Public Service for the year 2019 to 2020. That has been given to, in recognition for his contribution to a number of areas, has been given to our colleague Senator Floyd Morris, Dr. Floyd Morris. And his contribution is well known to us. And this is a most prestigious award which is presented to a staff member of the University of the West Indies who has gone beyond the call of duty and given exceptional public service. We are aware of his contribution in this chamber, but it is good that that contribution is recognized by persons outside the chamber as well. So I know that you will join me in congratulating our colleague and asking or requiring that his recognition is placed on the record of this Honourable Senate. I know that Senator Scott Motley wanted to say a few words, and I believe that Senator Cavan Gale has claimed seniority in order to respond. Senator Scott Motley.
Thank you, Mr. President. As you have so appropriately noted, this is a real recognition of the contribution which Senator Floyd Morris has made in academia, in social policy, and I think in his representation of persons with disabilities. His book is entitled Faith Without Sight? Not by sight, but by faith.
By faith, not by sight.
Why am I getting it wrong this morning? It was such an important occasion. But But the whole essence of it, though, sometimes, Mr. President, your destiny lies in a particular place and in a particular way. And I think that the fact that he lost his sight, it has propelled Senator Morris to be exceptional at everything that he has done. It is noteworthy that there were quite a few persons, both nationally, regionally, and internationally, being considered for this award. And it is not surprising to me, having regard to my close association with Senator Morris, that he has leapfrogged above all of them to be the recipient of this great honor. Of course, we know that he has had recognition by the United Nations in his own right. We know that the region has honored him. But I think that because of his academic pursuit and because of the reason for this award, as it weighs your contribution in so many different spheres, this one means a lot to him. We congratulate him. We know that there's a lot more coming. We look forward to, in this Senate, having the opportunity to recognize it when it happens. And I want to say that his acclamation is very well deserved. If it pleases you, Mr. President.
Thank you very much, Senator Scott Motley. Senator Gill.
And Senator Floyd Morris is one that continues to shine, and he makes us very proud that he's among us. And he not only makes us proud, but he makes his family proud to see where he's coming from. Academia, good in the field as being a parliamentarian. And one of the key things about him is that he's an advocate for a group that needs the advocacy. And he does so well at it. And that is why today he's recognized and is given the award that is being presented to him. And we congratulate him for that. And it's not an easy feat for Senator Morris, who, I consider him someone who is challenged with sight, but as a visionary. And so, don't disturb me, Senator Brown. I can't hardly hear you. But the thing about it is that, notwithstanding his challenges, his self-esteem continues to rise. And he is motivated to the extent today where it is called his own self-actualization. And that is good. And so there are those in society who would look up at him and want to be like him. And he sets a great example. And that is why, Mr. President, the award that is presented to him, it is most deserving. It is most deserving. And so we want to congratulate you, Senator Morris. But we ask also that you continue to be the trailblazer that you are. And we look forward to other awards that you may have or receive in life. May it please you, Mr. President.
Thank you, Senator Gill. Senator Morris, would you like to respond? After all, we have come here to praise him today, not...
President. Thank you very much, colleagues, for your gracious commendations, and I'm deeply heartened and humbled by the recognition from the University of the West Indies. I tell you, you start on a journey and you do your work and you put it in an individual's on the gallery look and see what you're doing and make the recommendation, and you are rewarded, and you have to just keep on moving and keep on doing what you do. The recognition, the award comes within the context of my participation in various aspects of academic life in terms of research and advocacy for persons with disabilities nationally, regionally, and internationally, and also the fact that I've been contributing to the legislation in the development of Jamaica's legislative architecture over the past couple of years. And it's always joyful when you are working in an institution and the institution examines what you are doing and reward you for your effort. And I am deeply grateful for the recognition, and I'm also extremely delighted and grateful for the support that has been given to me by a number of individuals, because I am not seen, and it requires support, and the support that I am given has contributed to the various successes that I've had. And I have to just keep on pressing and just keep on fighting for, as Senator Gale says, one of the most vulnerable groups within the society that individuals tend to forget from time to time. And so I'm extremely grateful and extremely heartened, and commendations to the continuous support from my wife and family, and also to the team at the university, who, I tell you, colleagues, I am working at the University of the West Indies, and I'm extremely grateful to the institution for the tremendous support that they have given to myself and also students with disabilities that are there at the institution. May it please, Mr. President.
Thank you, Senator Morris. Statements by ministers. Announcements. Bills brought from the Honourable House of Representatives. Petitions. Papers. Reports from committees. Notices of motions given orally. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Thank you, Mr. President. Mr. President, allow me to start by expressly associating myself with the interventions made by both the Leader of Opposition Business in the Senate and Senator Gale on our behalf in adding their commendations, or rather in stating their commendations to former President Senator Morris. We know your star will continue to shine and to rise. So I add my very brief commendation as well. Yes, we have to talk. We have to talk, and then there may be another announcement. Be it as it is. But it will be a good day, Mr. President. We are, as you know, dealing with the Data Protection Bill 2020, one that is long awaited and one which is one of, I would say, the most important and life-changing pieces of legislation that I think we will all, as senators, deal with over our lives in the Senate. It is therefore intended not to rush the debate. If it is that there are more persons who wish to speak beyond today, then they will accommodate it for us to finish the debate next week. It of course has been in Joint Select Committee for some time, has been the subject of several town halls, many interventions, and I will just very briefly refer in my opening. But it is a recognition of the importance of the matter before us, and certainly the intent to ensure that those who wish to share their perspective have the opportunity to do so. Mr. President, the bill will play a critical role in the protection of privacy of personal data, including sensitive personal data. Members of the Senate will recall that the bill was first tabled in October 2017 and that a Joint Select Committee was established to consider and report on the bill. The committee, which had its very first meeting in November 2017, concluded its deliberations in February of this year, having received and heard submissions from approximately 26 entities and individuals, as well as town halls and consultations beyond the precincts of this Parliament. In light of the number of amendments proposed to the bill, the committee recommended that the Data Protection Bill 2017 be withdrawn and a new bill tabled. And it is this bill, Mr. President, which is before us today, the Data Protection Bill 2020. The debate on that bill started in that other place on May 13th, and it was passed without amendment on the 19th of May, Mr. President. Mr. President, the right to privacy has been universally recognized as one of the inalienable rights of humans, as evidenced by the United Nations recognition of same in its 1948 Universal Declaration of Human Rights. In recognition of the Universal Declaration, the Jamaican Constitution was amended in 2011 to provide for a new Charter of Fundamental Rights and Freedoms, which in Section 13, sub 3J, provides that everyone has the right to, and I quote, respect for and the protection of private and family life and privacy of the home, and 2, protection of privacy of other property and of communication. Mr. President, thus are enshrined the rights which have long enjoyed legal protection by citizens of other countries, and this was in 2011. Mr. President, notwithstanding this inclusion in the Constitution, modern jurisprudence has long recognized that simply providing for and protecting the right to privacy in a constitution is not sufficient to adequately safeguard such a right, and hence there emanated the need for legislation to further address the protection of personal data. In fact, Mr. President, the European Union, through its Charter of Fundamental Rights, establishes, in addition to the right to privacy, a right to the protection of personal data concerning an individual, to include the fair processing of same based on the individual's consent or some other legitimate basis determined by law, and 2, the individual's right of access to data which has been collected concerning him or her, and the right to have it rectified. Mr. President, Jamaica's impetus for promulgating data protection legislation are many and varied. While obviously informed by the Constitution, other factors have also played a pivotal role. These include the advancement in technology and the increasing ability to process, store, data mine, and distribute personal data, the increase in electronic commerce in light of the evolution of the internet and its spread. Obligations imposed by bilateral and multilateral agreements, specifically trade agreements such as Economic Partnership Agreement between the EU and CARIFORUM member states. The objectives of the bill in this context, Mr. President, are therefore to define the general principles for the treatment of personal data and to provide for transparent oversight that will enable the public and private sectors to strengthen their protection of personal data. Mr. President, with that brief introduction, I will now turn to the clause-by-clause presentation. This may take us into next week. Mr. President, no, it's not for your ears, Mr. President. Clause 1, Mr. President, in addition to establishing the short title of the bill, provides that same shall come into operation on a day appointed by the Minister by notice published in the Gazette. It also makes provision for different days to be appointed for different provisions of the bill and different types of personal data. And just to indicate that in the first instance, for example, it is intended that the clauses which bring the operations of the office into effect will first be implemented so as to ensure that the operations can come in and then effectively administer the bill. So the intention is not that the entire bill will come into effect on passing within these houses. It will be to establish a structure. I'm advised that a consultant has already been retained and has defined the framework such that when the bill is passed and the appropriate steps taken, then an approach can be made to the Ministry of Finance for the establishment of the office to ensure that when, therefore, the various clauses are implemented in the appropriate phases, the appropriate protection may be given immediately. Mr. President, Clause 2 seeks to introduce definitions for terms used throughout the bill, as is usual. But for example, biometric data, data controller, data subject, personal data, processing, and sensitive personal data. For the purposes of the legislation, and Mr. President, I will only share a few, but a data controller, and it's important to understand because there are certain clauses, certain definitions you must understand to understand how the bill operates. And a data controller is a person or public authority who either alone or jointly with others determines the purpose and the manner in which personal data is or is to be processed, as well as a person on whom an obligation is placed by law to process same. So a data controller could be anybody, any authority, ministry, department, agency, a bank, utility, any company or any personal, natural or otherwise, who manages or processes personal data. A data subject is a named or otherwise identifiable individual who is the subject of personal data. So my name, my age are personal data that relate to me, the data subject. Personal data means information, like my name or age, however stored, relating to a living individual or an individual who has been deceased for less than 30 years, who can be identified from that information alone or from that information and other information in the possession of or likely to come into the possession of the data controller. And Mr. President, sensitive personal data means personal data consisting of information regarding a data subject's genetic or biometric data, affiliation, racial or ethnic origin, political opinions, philosophical, religious or other beliefs, trade union membership, physical or mental health condition, sex life, alleged commission of an offense or any proceedings for any offense alleged to have been committed by the data subject. Mr. President, Clause 3 indicates that the bill is applicable to the processing of personal data by A, data controllers who are established in Jamaica or anywhere that Jamaican law is applicable by virtue of international public law, or B, data controllers who, although not established in Jamaica, use equipment located in the island for the processing of personal data, otherwise than for transit through Jamaica, or process personal data of an individual in Jamaica, and the processing activities are relating to the offering or goods of goods or services to individuals in Jamaica, regardless of whether a fee is required, and related to the monitoring of behavior of individuals insofar as their behavior takes place within Jamaica. So of course this is important because you can have servers containing data in countries other than where business is provided. So the scope for the bill, in order to be effective, must be international in the same way that persons who operate here now, once they operate with companies that reside in places like the EU where there is strong data protection legislation, must adjust their procedures and processes for legal compliance with their overseas partners or business associates. Mr. President, so that clause imposes a requirement on a data controller established outside of Jamaica to appoint a representative established here in Jamaica, and that is to ensure that matters can be enforced and complied with. Mr. President, Clause 4 of the bill establishes the Office of the Information Commissioner, hereinafter called the Commissioner, and it's established as a body corporate in accordance with the Interpretation Act, and it also outlines the duties of the Commissioner. These duties include monitoring compliance with the legislation and attendant regulations, providing advice to the Minister, disseminating information to the public concerning, among other things, the operation of the legislation, and preparing and disseminating, directing the preparation and dissemination, or encouraging the preparation and dissemination of guidelines that promote good practice. Additionally, the clause provides for the establishment of a Data Protection Oversight Committee to enable supervision of the Commissioner in the performance of his or her duties. Mr. President, Part 2 of the bill, which covers clauses 5 to 13, establish the right of data subjects regarding their personal data. So your right in respect of data about you. So, Mr. President, in the case of a minor, his or her rights can be exercised by a parent or a legal guardian, or by the minor, him or herself, in any case where the law recognizes the capacity of the minor to act in the matter to which the data relates. The right of an individual with a mental impairment may be exercised by the individual's nearest relative within the meaning of Section 3 of the Mental Health Act. And Mr. President, the right of any other individual may be exercised by their legal personal representative or any individual to whom he or she delegates in writing the power to do so. Mr. President, Clause 6 establishes the right of an individual to access his or her personal data. Very important. On making a written request to a data controller, an individual is entitled to be informed free of charge whether the data controller is processing personal data related to him or her, and if so, to be provided with a description of the data, the purpose or purposes for which the data is being processed, and the person or persons to whom the data has been or may be disclosed. And I don't know if any of you watched the documentary on Cambridge Analytica, and where it all started was an individual seeking to have disclosed to him information that was held by him by a data collection company. That's how the whole issue unfolded. One individual seeking to exercise their rights under the EU data protection regulations, and it was in relation to this. So, Mr. President, an individual is also entitled, upon the payment of a fee, to be provided in an intelligible form with the data that relates to him or her, to have personal data relating to him or her transmitted to another data controller, specified in the request where this is technically feasible. So this, Mr. President, is the right of data portability, and to be informed of the logic involved in a decision where the processing is by automatic means for the purposes of evaluating matters such as work performance or creditworthiness of the individual, and is likely to be the sole basis for any decision significantly affecting the individual. So like requesting of a credit bureau, your credit data. So, Mr. President, the data controller is required to comply with an access request promptly, but no later than 30 days or such longer maximum period as may be prescribed. 7 addresses the manner in which and the extent to which information requested under Clause 6 is to be provided, and it takes into account, Senator Morris, the need to provide the data in a form that would render the information readily accessible to persons living with a disability as defined by the Disabilities Act. So that's Clause 7. Clause 8, Mr. President, outlines the grounds on which a data controller is allowed to refuse an access request made under Clause 6. And the grounds include where the data controller requires more information to satisfy itself as to the identity of the person making the request and to locate the information requested, where disclosing the information might might involve disclosing other information related to another individual and the consent of that individual has not been obtained, or it's not reasonable to disclose the information without consent. Where the request is identical, Mr. President, or similar to a previous request and a reasonable interval has not elapsed since compliance with the previous request, so it's unlikely to have changed. And where disclosing the logic for any decision would constitute a disclosure of a trade secret. Mr. President, Clause 9 outlines what consent means when it's required to enable processing of personal data. And in this regard, it is defined as any, and I quote, informed, specific, unequivocal, freely given expression of will by which a data subject agrees to the processing of his or her personal data. And it includes any consent given by an individual acting on behalf of an individual or a minor or a person with a mental impairment. Clause 10, Mr. President, establishes the right to prevent data marketing, direct marketing, and in this regard, a data controller is prevented from processing personal data for direct marketing unless the data subject gives consent or is a customer of the controller. Direct marketing occurs when a data subject is approached personally or by any means of communication, whether electronic or otherwise, for the direct or indirect purpose of promoting or offering to supply in the ordinary course of business any goods or services, or requesting a donation of any kind for any reason. So, Mr. President, a data controller is precluded from approaching a data subject more than once in order to request his or her consent. And where the data subject is a customer of the controller, his or her personal data may only be processed if his or her contact details were obtained in the context of the sale of any goods or services, for the purposes of direct marketing the controller's own similar goods and services, or if the data subject has been given reasonable opportunity to object, free of charge and without unnecessary formality, to such use, A, at the time the personal data was collected, and 2, on the occasion of each communication with the data subject for the purpose of direct marketing if the data subject had not refused it. Mr. President, Clause 11 gives data subjects the right to prevent the processing of their personal data in certain specified circumstances. And these circumstances include where the processing is causing or likely to cause substantial damage or distress, and the damage or distress caused or likely to be caused is unwarranted, and where the data is incomplete or irrelevant, or where the processing of the data is prohibited by law, the purpose of the processing, or where the data has been retained for longer than required by law. A data controller who receives a notice to cease or not begin processing must give effect the same within 21 days of receiving the notice and provide a written statement of the action taken. Mr. President, processing cannot be prevented in certain instances, however, and these include where consent has been given by the data subject, where processing is necessary for the performance of a contract or taking steps to enter into a contract, where processing is necessary for complying with legal obligations imposed on the data controller, where the data subject has published the data concerned already, and processing is necessary to protect the vital interest of the data subject. Mr. President, Clause 12 entitles a data subject to request that a data controller ensures that no decision which would significantly affect him or her is taken solely on the basis of the results of automated processing. These decisions include matters concerning the evaluation of data subject's work performance, creditworthiness, reliability, or conduct. If the data controller has received no notice from the data subject to that effect, the controller is obliged to inform the data subject that the decision was based on automatic processing. And the data subject then has 30 days to request in writing that the decision be reconsidered or be made using non-automated processing. The data controller then has an additional 30 days to respond to the data subject's request. Mr. President, it's to be noted that there are exemptions to this right and the request can be denied, for example, if the decision is authorized by or required by law, if the decision is made in the course of considering whether to enter into a contract or performing a contract, or the effect of the decision is to grant requests of the data subject. Thank you. Mr. President, Clause 13 provides that an individual may, in writing to a data controller, request that the controller rectify any inaccuracy in data in its possession or control and of which the individual is the data subject. The data controller has 30 days to determine whether a rectification is required and to notify the individual of the manner in which his or her request was handled. Mr. President, Part 3 of the bill comprises clauses 14 to 20 and outlines the requirements that data controllers are obliged to meet. So, Mr. President, clauses 14 to 18 address the issue of registration. So in this regard, clause 15 prevents a data controller from processing personal data unless its registration particulars are included in the register to be maintained by the commissioner. So it's an obligation. If you're going to be processing personal data, you need to be registered with the office. The registration particulars that are to be provided are outlined in clause 16, and they include name and address, other relevant contact info, description of personal data to be processed, or the category or categories, description of the purpose or purposes of the processing, description of any person or persons to whom the controller intends or wishes to disclose the data, the names of any countries to which the controller directly or indirectly transfers, intends to, or wishes to directly or indirectly transfer the data, and a general description of the technical and organizational measures to be taken to ensure security of processing. Mr. President, it's to be noted that after consultation with the Commissioner and subject to affirmative resolution, the Minister may designate the processing or the data controllers that are not required to register. However, processing that is so designated must be processing that is unlikely to prejudice the rights and freedoms of any data subject. Mr. President, if a data controller who has not provided registration particulars is asked in writing to do so, the controller shall make the particulars available to the person free of charge within 30 days after receiving the request, and it's an offense to fail to provide them, Mr. President. The data controller can be liable upon conviction to a fine not exceeding $1 million. Clause 17 mandates the Commissioner to maintain the register, and an annual fee is required for the maintenance. And Clause 18 makes it an offense to process data without registering, Mr. President, where registration is required. And that offense attracts a fine of $2 million or imprisonment for a term not exceeding 6 months. Mr. President, this is 2 or up to Clause 18. Clause 19 empowers the Minister to designate by order, subject again to affirmative resolution, certain processing as specified processing. And that is processing which is likely to cause, defined as likely to cause substantial damage or distress, or to otherwise significantly prejudice the rights and freedoms of data subjects. And the clause requires the Commissioner to assess whether processing being undertaken by a data controller is or is not specified processing, and to communicate the outcome of his or her assessment to the controller within 30 days or such longer period as determined by the Commissioner. It's an offense to carry out specified processing without providing registration particulars and without receiving notification from the Commissioner. And an individual convicted on summary conviction of this offense can be liable to a fine of up to $5 million or imprisonment for a term not exceeding 5 years, and on conviction on indictment to a fine or imprisonment for a term not exceeding 10 years. So the matter of specified processing is viewed quite strongly, Mr. President. Clause 20 makes provision for the appointment by data controllers of an appropriately qualified person as a data protection officer. So the officer is responsible for monitoring in an independent manner the data controller's compliance with the provisions of the legislation. And the functions of the data protection officer include consulting with the commissioner to resolve any doubt about how the legislation and regulations made are to be applied, ensuring that any contravention of the data protection standards or any provisions of the legislation by the data controller is dealt with, and assisting data subjects in the exercise of their rights. Mr. President, not every data controller will be required to appoint a data protection officer. Those who are not required are public authorities, controllers that process or intend to process sensitive personal data or data relating to criminal convictions, controllers that process personal data on a large scale, and controllers that are designated by the commissioner as not requiring a data protection officer. So those who are which are specifically exempt are those who process personal data only for the purposes of a public register, and those who are non-profit organizations established for political, philosophical, religious, or trade union purposes. Mr. President, Part 4 of the bill, which covers clauses 21 to 31, establishes 8 standards that data controllers will be required to adhere to for the protection of personal data. Clause 21 imposes a duty on data controllers to comply with the standards, and a controller who processes personal data in contravention of any of the data protection standards or any of the provisions of Part 4 shall be liable on summary conviction to a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years, and upon conviction or on conviction on indictment, imprisonment for a term not exceeding 7 years, or of course a fine. Mr. President, data controllers are required to notify the commissioner of any contravention of the standards and or any security breach which affects or may affect personal data. So it's not okay to just simply cover up an issue, a data breach, because you don't want your business to have any public, any prejudice in the minds of the public. You can't cover it up. You must disclose to the commissioner, not public. You must disclose if you have had a breach within 72 hours after becoming aware of the contravention or the breach. And they're also required to notify each data subject within such time as prescribed of the contravention of security or security breach on becoming aware of or having reason to become aware of same. Mr. President, clauses 22 to 24 address the first data protection standard, which is that personal data must be processed fairly and lawfully. And the standards essentially considers the method by which personal data is collected. In this regard, data must not have been obtained by deception or misleading the individual as to the purpose for which the data is being collected. In ensuring that personal data is processed fairly, at least one of the conditions set out in Clause 23 must be present. So either that the data subject has given consent, that the processing is necessary for the performance of or entering into a contract, the processing is necessary for complying with legal obligations imposed on the data controller, the processing is necessary for protecting the vital interest of the data subject, the processing is necessary for the administration of justice or the exercise of any functions of a public nature to be exercised in the public interest, and the data subject has published the data concerned. Clause 24, Mr. President, outlines additional conditions, one of which must be present when processing sensitive personal data. And one such condition is, of course, that the data subject has given his or her consent. Mr. President, Clause 25 establishes the second data protection standard, which is that it must be obtained only for one or more specified and lawful purposes and shall not be further processed in any manner incompatible with these purposes. Clause 26 provides the third, which is that personal data shall be adequate, relevant, and limited to what is necessary for the purposes for which they're processed. And 27 establishes a fourth standard, which is that data shall be accurate and, where necessary, kept up to date. In clause 28, the fifth standard is that personal data shall not be kept for longer than is necessary for the purpose and shall be disposed of in accordance with regulations made under clause 74 of the legislation. Clause 29 establishes the sixth data protection standard, which is personal data shall be processed in accordance with the rights of data subjects as established under the legislation. And clause 30 provides for the seventh data protection standard, which is that appropriate technical and organizational measures shall be taken, 1, against unauthorized or unlawful processing and accidental loss or destruction of or damage to personal data, and to ensure that the Commissioner is notified without undue delay of any breach of the data controller's security measures which affect or may affect any personal data. So the clause also provides some guidance about the types of technical and organizational measures that can be taken and the requirements that must be met where processing is being carried out by a data processor or on behalf, rather, of the data controller. And Mr. President, for the record, it is an offense to willfully and without lawful authority breach any pseudonymization, which was a new name for me, or encryption applied to any personal data. A person so convicted shall be liable before a parish court, again, to a fine not exceeding $2 million, or before a circuit court to a fine. Mr. President, Clause 31 establishes the eighth and final data protection standard. That is, that personal data shall not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights and freedoms of data subjects in relation to the processing of personal data. So you can't just say the server is located in country X. You have a responsibility to ensure that country X provides in its laws for the protection of the rights and freedoms of data subjects in relation to the processing of data. And the adequacy of those laws elsewhere will be determined by a list of factors, including the nature of the personal data, the state or territory of origin or final destination, so depending on where it's being processed. The issue could be to assess here or there, and the purposes for which and the period during which the personal data is intended to be processed. Mr. President, you should also consider the law in force in the state or territory in question and the security measures taken in relation to personal data in the destination state or territory. It should be noted, however, Mr. President, that there are exceptions to the 8th standard, and these include where the data subject consents to the transfer, where the transfer is necessary for the reasons of substantial public interest, and where the transfer is for the purposes of national security or the prevention, detection, or investigation of crime. Mr. President, the clause permits the Minister, by order published in the Gazette, to prescribe the states and territories which shall be taken to have an adequate level of protection. Mr. President, Part 5 deals with exemptions to data protection standards or to disclosure to data subject requirements. So in clauses 32 to 43, the bill examines the instances in which a data controller will not be required to comply with certain provisions of the legislation. Clause 32 represents the interpretation clause for this Part 5. It notes that, quote unquote, disclosure to data subject requirements shall have effect notwithstanding any enactment or rule of law prohibiting or restricting the disclosure or authorizing the withholding of information. So disclosure to data subject requirements shall have effect notwithstanding any enactment or rule of law prohibiting or restricting the disclosure or authorizing or withholding information, authorizing the withholding of information. And disclosure, and Mr. President, it means that the information which data controllers are required to provide to data subjects pursuant to clauses 22.6 and the data subject's right of access under clause 6. Mr. President, clause 33 empowers the Minister of National Security, after consultation with the Minister of Technology, to issue certificates exempting any personal data from all or any of the provisions of the data protection standards. And parts 2, 3, and 6, and clause 61 regarding unlawfully obtaining personal data. The certificate must, among other things, identify the personal data to which it applies and specify the provisions of the legislation from which the data is exempt. So, Mr. President, where an appeal is made against the issuing of a certificate and it's found that the minister did not have reasonable grounds for issuing same, the court may allow the appeal and quash the certificate. Mr. President, clause 34 provides that personal data processed for the prevention, detection, or investigation of crime, the apprehension or prosecution of offenders, or the assessment or collection of any tax or duty are exempt from the first data protection standard, and that is that data shall be processed fairly and lawfully. Clause 6, regarding the right of access to personal data, and the non-disclosure provisions. Mr. President, the non-disclosure provisions are that the first data protection standard, except to the extent that the disclosure is required for compliance with the conditions outlined in 23 and 24, the second to fifth data protection standards, clause 11 regarding the right to prevent processing, and clauses 13, 3, and 4 regarding rectification of inaccuracies. Mr. President, personal data processed for the purpose of discharging statutory functions are exempt from the disclosure to data subject requirements. Mr. President, clause 35 exempts from the disclosure to data subject requirements personal data processed for the purposes of discharging, among other things, a function conferred by law, a function of a public nature, and a function designed to protect the public from maladministration by public authorities. Clause 36 provides that personal data which is processed only for special purposes, that is, journalism, artistic, or literary purposes, are exempt from all the data protection standards except the 7th standard concerning security safeguards. Clause 6, which is the one related to disclosure, and clause 12 regarding rights in relation to automated decision taking, and clauses 13, 3, and 4. Mr. President, the exemptions are applicable if the processing is with a view to publishing any journalistic, literary, or artistic material. The publication would be in the public interest, and in all the circumstances, compliance with the provisions I previously mentioned would be incompatible with a special purpose. So this is the media exemption clause that has been much discussed in the public domain. I'll just term it that, so anyone who wants to go back to look at that for discussion and debate, that is clause 36, and it is the one that exempts, it exempts such data processing from almost everything in the Act. But it'll be interesting to hear the debate on these issues for those of us who were not in the Joint Select Committee. Mr. President, clause 37 offers exemptions for personal data which are processed only for research purposes, including statistical and historical purposes, provided the following conditions are met. 1, that the data is not processed to support measures or decisions regarding particular individuals. 2, that the data is not processed in such a way that causes or is likely to cause substantial damage or distress to any data subject. Where the relevant conditions are satisfied, the processing will not be regarded as incompatible with the second data protection standard, that is the purpose limitation standard, and the personal data can be kept indefinitely, notwithstanding the terms of the fifth data protection standard, that is the retention limitation standard. And this is, of course, because, as we indicated, this is for statistical and historical purposes, so you would clearly expect it not to have a limitation of time. So, Mr. President, with respect to processing for archival and historical purposes, bless you. Excuse me, sir. And somebody give him a spritz or two. Let's say 9 feet, Floyd. Let's say it can travel 9 feet. Mr. President, with respect to archival and historical purposes.
You're happier that far.
That was just Senator Horton exited just in time. No. But I did mean the blessings. So, yes, sir, a data controller may disclose personal data if the relevant conditions are met, and A, the personal data relates to an individual who has been deceased for 30 years or such number of years as prescribed, and B, that the personal data are in a record which has been in existence for 30 years or such number of years as may be prescribed. Mr. President, Clause 38 exempts personal data consisting of information which the data controller is obliged under any statute to make available to the public from the disclosure to data subject requirements, the fourth data protection standard, that is that data must be accurate and up to date, Clause 13.3 and 13.4, and the non-disclosure provisions. Mr. President, Clause 39 provides for exemption from the non-disclosure provisions where disclosure is required by any law, by any rule of law, or by order of the court, is necessary for the purpose of or in connection with legal proceedings, including prospective legal proceedings, and is necessary for the purpose of obtaining legal advice, or is otherwise necessary for the purposes of establishing, exercising, or defending legal rights. Mr. President, Clause 40 exempts personal data from certain provisions of the legislation if exemption is required for the purpose of avoiding an infringement of the privileges of either House of Parliament. The exemptions would relate to the first data protection standard, so the exception to the extent that consent from the subject is required, the second to fifth data protection standards, and clauses 6.11 and 13.3 and 4. Mr. President, Clause 41 exempts personal data processed by an individual only for the purposes of that individual's personal, family, or household affairs. So if you're pulling things together for a family scrapbook, or you're, compiling information for pure enjoyment within your personal, family, or household affairs, or recreational purposes, a running group, something like that, it's exempt from the data protection standards and the provisions of Parts 2 and 3. So the event is not to say once you are pulling together any personal data whatsoever, all of this is required. It is where it's being required for purposes which either have commercial or national, public, or private interest. But this exemption is important to understand that the scope of the bill is not unreasonable in all the context. Mr. President, Clause 42 and the second schedule work together. Clause 42 provides for the other miscellaneous matters that are exempt from certain provisions of the legislation. And all of these matters are outlined in the second schedule. They include exemptions for confidential references given by the data controller, personal data that would prejudice the combat effectiveness of the JDF, personal data processed for the purposes of appointing judges and Queen's Counsel and the conferring of honors or awards, personal data processed for corporate financial services, personal data concerning which legal professional privilege could be claimed, and circumstances in which by granting access a person would incriminate himself in respect of an offense other than one under legislation. Mr. President, Clause 43 empowers the Minister to exempt from the disclosure to data subject requirements personal data, the disclosure of which is statutorily prohibited or restricted if the Minister considers it necessary for safeguarding the interests of the data subjects or the rights and freedoms of any other individual. Mr. President, Part 6 deals with enforcement, and this is clauses 44 to 55, and it essentially makes provision for the Commissioner to issue enforcement, assessment, or information notices. Clause 44, Mr. President, empowers the Commissioner to issue enforcement notices in instances where the Commissioner is satisfied that the data controller has contravened or is contravening any of the data protection standards. The Commissioner should consider whether the contravention has caused or is likely to cause any individual damage or distress at the point when deciding to serve an enforcement notice. And Mr. President, the notice issued may require the data controller to take or refrain from taking steps within a specific time, to refrain from processing any personal data or personal data of a specified description, or to refrain from processing data for a specific purpose or in a specific manner after a specific time. Mr. President, Clause 45 imposes an obligation on a data controller, unless exempted, to submit to the Commissioner annually a data protection impact assessment regarding all data in its custody and control. Upon receipt of the data protection impact assessment, the Commissioner must review and issue directions to the data controller, where appropriate, regarding amendments to the controller's system of operations or activities or the implementation of other recommendations. Additionally, the clause outlines the information that must be contained in the data protection impact assessment and empowers the Commissioner to specify by notice published in the Gazette the classes of personal data or data controllers which are required or not required to submit a data protection impact assessment. Mr. President, Clause 46 enables any person who is or believes himself to be directly affected by the processing of personal data to require the Commissioner to carry out an assessment of whether the legislation is being complied with. Following his or her assessment, the Commissioner is required to notify the individual whether an assessment has been made and, if appropriate, the conclusion formed or action taken as a result of the request. So this clause is important for citizen enforcement. Citizens have a right to be told. You not only have a right to report, to make a report and to request for action to be taken, but you must be notified whether any action was taken, and if so, what and why. And that's quite important in matters which are often sensitive once you're dealing with personal data. That's 46. Clauses 47 and 48, Mr. President, address the issuing of assessment notices. Pursuant to Clause 47, assessment notices may be served for the purpose of enabling the Commissioner to determine whether the data controller is complying with the data protection standards. So the notice may require the data controller to permit entry to premises, assist the Commissioner to view any information of a specified description. So you would, it's not like they would just come in and once it's encrypted, they'd be stuck. You need to give them access to the information, explain how it's being collected and how it's being managed to ensure that it is in fact being managed appropriately and in accordance with the legislation. The notice may require a copy or copies of the documents to be viewed, and it may permit the Commissioner to inspect or examine the documents, information, equipment, material.
The Minister's, sorry, go ahead.
Minister's time having expired, may I ask that it be extended to allow her to complete her presentation?
You've heard the question. Those in favor? Those against? The ayes have it.
Thank you, Mr. President, and I offer my personal congratulations to all who remain of listening ears. Oh, Mr. President. So the notice may also require the Commissioner to make available for interviews such persons, such specified persons who are required. And again, this is about enforcement. So it's making sure that you can't just have technical compliance where you allow access, but the access is such that because of the technology being used or the manner of storage is such that the Commissioner is unable to really assess compliance. So I think this is quite well crafted. Mr. President, Clause 48 indicates, Clause 47 also imposes a requirement on the Commissioner to issue a code of practice regarding the manner in which he or she will exercise his or her power to prepare and issue assessment notices. So again, this is about good governance and ensuring that with all of this power and all of this access, that there is predictability and transparency and consistency in the way these expansive powers are exercised. So there will be a code that guides how they exercise their duties under this Act. Mr. President, Clause 48 indicates that the requirement imposed by an assessment notice will not have effect so far as compliance with same would result in the disclosure of any communication that is subject to legal professional privilege or would expose a person to proceedings for an offense by revealing evidence of the commission of that offense. So here we have legal advice protected, because certainly if it is that, and lawyers process personal data. They collect personal data. They have, their files are stacked with personal data. So it's not always about technology and processing of transactions. The fact is that the legal profession concerns itself with personal data, and therefore this provision of privileged information, and how evidence is treated is very important for the protection of the practice of the law. But additionally, so it limits the scope of such an assessment notice. And additionally, an assessment notice can't be served on a member of the judiciary or bodies falling within the definition of security or intelligence services under the Access to Information Act. So it preserves a particular type of protection that's already given. Mr. President, Clause 49 enables the Commissioner to serve an information notice on a data controller where he or she requires certain specified information to be furnished. And the notice may be served where the Commissioner, among other things, has received a request from a data subject for an assessment in relation to a data controller's compliance, or requires the information in order to determine whether a data controller is complying with the legislation. So it's whether they're acting on their own motion or a request from a data subject. Mr. President, it's to be noted that a person can't be required to furnish the Commissioner with any information, again, if it is legally privileged, or it would expose him or her to proceedings for an offense by revealing evidence of commission of offense. Mr. President, Clause 50 empowers the Commissioner to make a determination as to whether personal data is not being processed only for a special purpose, you remember earlier, and this is artistic, literary, and journalistic purposes. So a Commissioner can say that no, it is actually not, or yes, it is. This is a journalistic endeavor, it's an artistic endeavor. It can make a finding. And, or, Mr. President, it can also make a determination with a view to the publication of any journalistic, literary, or artistic material. So it is not, if someone seeks to prevent, they can always make a determination otherwise. Mr. President, notice of the determination, however, must be given to the data controller concerned and contain the particulars of the right of appeal. Mr. President, Clause 51 prevents the Commissioner from serving an enforcement notice where processing is being carried out for special purposes unless a determination whether personal data is not being processed only for special purposes or with a view to publication has taken effect, and if the court has granted leave for the notice to be served. So in order for the court to grant leave, the court must be satisfied that A, the commissioner has reason to suspect a contravention of the data protection standards, which is of substantial public importance, and B, the data controller has been given, in accordance with the rules of court, notice of application for leave, except where the case is one of urgency. Mr. President, Clause 52 provides that anyone who fails to comply with an enforcement, assessment, or information notice commits an offense. And in addition, a person who makes a false statement or recklessly makes a statement which is false in a material respect in purported compliance with an information or an assessment notice also commits an offense. And a person may be charged for any of these offenses a fine not exceeding $1 million. Mr. President, clauses 53 and 54 address the data controller's right of appeal. And in this regard, a controller who has been served with an information, enforcement, or assessment notice has the right to appeal to the court against the notice. And the court, on consideration, may allow or dismiss an appeal, substitute, cancel, or vary the notice, or indeed quash the determination of the commissioner. Clause 55 works with the third schedule, Mr. President, and together they empower the commissioner to enter and inspect premises of a data controller. I've already given some limitations already, but in this regard, the third schedule outlines the procedures necessary to obtain and execute a warrant so as to enable the commissioner to enter and search premises, to inspect, examine, operate, and test any equipment found on the premises, and which is used or intended to be used for the processing of personal data, to inspect and seize any documents, and to require any person on the premises to provide such information as may reasonably be required for the purpose of determining whether the data controller has contravened, is contravening the data protection standards. Mr. President, the schedule specifically provides that the powers of inspection and seizure cannot be exercised in relation to personal data exempt by virtue of a certificate issued by the Ministry of National Security under Clause 33, and any communication between an attorney at law and his or her client in connection with the giving of legal advice or in contemplation of proceedings arising under or out of this legislation. So certainly the commissioner couldn't be coming to exercise seizure of matters which were related to an action being brought against the commissioner. That's the second leg. So part 7, Mr. President, miscellaneous and general, we are getting there. It covers clauses 56 to 77 and makes general provision for, or rather provision for general matters relating to the operation of the legislation. So clause 56 requires the commissioner to lay an annual report and such other reports as deemed necessary before the Houses of Parliament, and it requires guidelines prepared by the commissioner to be laid before the Houses of Parliament. So again, there's a level of oversight. Clauses 57 and 58 treat with the matter of a data sharing code. And in this regard, Mr. President, 57 mandates the commissioner to prepare and submit to the minister after the requisite consultations a data sharing code containing practical guidance concerning the sharing of personal data. And if the code is found to be in order, it shall be tabled before the Houses of Parliament for affirmative resolution. If not found to be in order, the commissioner is required to prepare another code. It's to be noted, Mr. President, that pursuant to clause 58, the failure on the part of any person to act in accordance with any provision of the code doesn't itself render that person liable to any legal proceedings in any court or tribunal. So it's not everything that is an offense, but there is guidance to be given about how personal data can be shared, and that is where it is not protected otherwise by the legislation. Excuse me. There is no closed bin to dispose this. So we'll have to go in good faith and cut and clear, as Senator Crawford was saying. Clause 59, Mr. President, it enables an individual who is an actual or prospective party to a proceeding regarding personal data processed for journalistic, literary, or artistic purposes to apply for the Commissioner for assistance in relation to that proceeding. So, and Clause 60 empowers the Minister, after consultation with the Minister responsible for Foreign Affairs, to make regulations regarding cooperation with the Commissioner and authorities responsible for data protection in other countries. Mr. President, Clause 61 seeks to create 3 offenses. Firstly, an offense is committed if a person knowingly or recklessly, without the consent of the data controller concerned, A, obtains or discloses personal data or any information contained therein, or B, procures the disclosure to another person of any information contained in personal data. And the offense will not be held to have been committed if the person is able to show, among other things, that obtaining, disclosing, or procuring the data was required or authorized by or under any law, rule of law, or court order, or was justified in the public interest. Secondly, it is an offense to sell personal data which was obtained or procured without the data controller's consent. And finally, it's an offense if a person offers to sell by advertisement or otherwise personal data which was obtained or procured without the data controller's consent. So people taking bulk numbers and selling them on in the way that they have, etc., without consent would be problematic, as a simple example. Mr. President, a person who commits any of these offenses is liable upon summary conviction in a parish court to a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years, or upon conviction on indictment in a circuit court to a fine or imprisonment for a term not exceeding 10 years. Again, treated quite seriously. Data protection is treated quite seriously under this Act. Clause 62 makes provision for the serving of fixed penalty notices if the Commissioner is satisfied, A, that a data controller has committed an offense to which the clause applied, that the contravention was of a kind likely to cause substantial damage or distress, and C, that the contravention was deliberate or the data controller knew or ought to have known that there was a risk that the contravention would occur and that same was likely to cause substantial damage or distress. A data controller is not liable to be convicted of an offense if the fixed penalty is paid and requirements respecting which the offense was committed is complied with. So again, there's an effort not to try to clog up the courts where matters can be dealt with pragmatically and with some penalty. They will so be done. Clause 63 works with the 4th schedule, Mr. President, and Clause 63 makes it an offense to require the production or supply of certain records as a condition of the provision of goods, facilities, or services, unless the person can show that the imposition of the requirement was authorized by law or a court order, or was justified as being in the public interest. The records to which the clause applies are outlined in the 4th schedule of the bill and include convictions and returns of persons convicted of criminal offenses. On conviction of this offense, Mr. President, the person shall be liable to a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years on summary conviction in a parish court, or to a fine or imprisonment for a term not exceeding 5 years on conviction on indictment. Clause 64 deems void any contractual term or condition which requires an individual to produce or supply any health record or part thereof. Clause 65, Mr. President, provides for disclosure of information to the Commissioner or the Appeal Tribunal for the discharge of their functions unless the disclosure is precluded under any law or rule of law, protected from disclosure by legal professional privilege, or would be self-incriminating. Mr. President, Clause 66 prevents the Commissioner and staff of the office from disclosing any information obtained under or for the purposes of the legislation or that relates to an identified or identifiable individual or business unless the disclosure is made with lawful authority. Where a person knowingly or recklessly discloses information, he or she shall be liable on summary conviction in a parish court to a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years, and on conviction on indictment in a circuit court to a fine or imprisonment for a term not exceeding 10. Clause 67 makes for provision of the institution of proceedings for an offence under the legislation by the DPP or the Commissioner with the consent of the DPP. Clause 68 provides for the liability of directors, managers, secretaries, and other similar officers where a body corporate commits an offence. And in this regard, a body corporate may be liable to a fine not exceeding 4% of its annual gross worldwide turnover for the preceding year of assessment in accordance with the Income Tax Act. So that philosophy of making it felt in the pocket to disincentivize corporate, poor corporate behavior is embodied in this clause. Clause 69, Mr. President, provides for a person who suffers damage or distress by reason of any breach of the legislation by a data controller to receive compensation from the data controller. So again, that's another citizen protection. You're able to actually get compensation under this act. Clause 70 establishes a right of appeal to an appeal tribunal for persons aggrieved by a decision taken by the Commissioner, save and except decisions regarding enforcement, assessment, and information notices. 71, Mr. President, specifies the manner in which notices authorized or required by the legislation are to be served by the Commissioner on natural or legal persons. And Clause 72 provides that the legislation binds the Crown. However, public authorities are exempt from liability to prosecution. Mr. President, Clause 73 indicates that the legislation applies to the Houses of Parliament in respect of the processing of personal data, and that the clerk to the Houses is deemed to be the data controller for the purposes of this legislation. Clauses 74 and 75, Mr. President. 74 provides for regulations to be made for the better administration of the legislation, while 75 empowers the Minister to, by order, subject to affirmative resolution, amend any monetary penalty or fixed penalty imposed by the legislation. 76 establishes a transition period of 2 years to allow data controllers time to take the necessary steps to ensure full compliance with the legislation. Additionally, manually held data is exempt from certain provisions of the legislation until a date appointed pursuant to Clause 1 of the bill. Mr. President, Clause 77 makes provision for the review of the legislation every 5 years from the earliest day appointed pursuant to Clause 1. And I will now very briefly turn to the schedules in the bill. No, really, congratulations to you all. This is the final lap. No, this is actually it. This is actually it. Because remember, I've been discussing the schedules already, so it's really just referring to the others. So the first schedule is divided into 2 parts. Part 1 addresses the constitution of the Office of the Information Commissioner and includes matters relating to the appointment, tenure of office, remuneration, appointment of staff, funding, and protection from suit. Part 2 establishes a Data Protection Oversight Committee, which I mentioned earlier, and the objective of this is to hold the Commissioner accountable to the public in the performance of his or her functions. So again, it's very important about the balance between protection, accountability, where powers are so great. The objective of which, Mr. President, is accountability, and it speaks to, among other things, the constitution and tenure of the committee, appointment, removal, resignation, its functions and powers, procedures at meetings, remuneration, indemnity, and conflict of interest. There is an appendix to the first schedule, and this appendix addresses the pension and other benefits to be paid to or in respect of a person who holds the office or has held the office of Commissioner. And then the second, third, and fourth schedules I had dealt with already, which only leaves us with the 5th schedule, which addresses matters attendant to the appeal tribunal. And that appeal tribunal is established pursuant to Clause 70, as I mentioned earlier. But here in the 5th schedule, matters include the constitution and tenure of the tribunal, appointment, removal, resignation, procedures at meetings, and remuneration. So, Mr. President, personal data is processed in every conceivable activity that we are involved in. It really is quite mind-blowing when you think about what this bill applies to what it applies. When we conduct business, when we access services, when we entertain, when we travel, when we connect with others. So it is not surprising that data has actually been dubbed the new gold. As entities of all sizes accumulate growing volumes of personal data, and as the data are mined, analyzed, and shared, it becomes imperative that every attempt be made to protect the constitutional rights of individuals in relation to the privacy of their personal data. And this bill, Mr. President, therefore represents the government's intent to give effect to this constitutional right by delineating the rights of individuals in relation to the processing of their personal data and their sensitive personal data, as well as establishing the parameters within which personal data should be processed by data controllers in both the private and public sectors. So, Mr. President, I do look forward to support of members of both sides of the Senate in passing this bill, noting its extensive discussions to date, and I look forward to hearing the perspectives of members on the very interesting aspects of this somewhat lengthy bill. I thank you all for your attention, Mr. President.
Mr. President.
Just before I recognize you, Senator Fraser-Binns, just want to say that protocol does not allow the President to show any motion or knock on his table from up here. But sufficient to say that I found it most interesting, stayed through it, know about it, and this is vital, as you've said, Minister, this is vital and important for the nation. Thank you for the stamina that you've shown. I'm glad that you're a runner and everything else that you do. Yes, and before I recognize somebody else, you have something else to say.
Yes, pardon me. Just a note, just to thank the team that prepared the brief. It would have been an endeavor, an undertaking, and it was really very well done, very well crafted, a lot of attention to detail, and very important in its content and contextualization. So thank you very much. I express it on behalf of the Senate. Thank you.
And again, before I recognize, thank you so much. I know the work you've done, and I like especially Clause 77. It must be reviewed at least every 5 years, because this is changing so fast that it's important that you have some sort of a sunset clause or a pseudo-sunset clause that will force revision. Senator Fraser-Binns.
Thank you. Thank you, Mr. President. And Mr. President, I paid it forward in March, I believe, or April when I spoke. And I commit to my colleagues that today, having paid it forward, I shall be very brief. I too, Minister, want to join with you to extend congratulations and thank you to the team. Let me declare that I was a member of the Joint Select Committee, and I really admire the ability of the team, particularly Miss Murray and Katie, and you'll have to forgive me because I just cannot forget, I can't remember your last name. And I single them out because they're from the ministry, but it's not just the fact that they're always present, but their knowledge and then their ability to break down such a technical issue in a way that the ordinary man on the JUTC bus could understand. And I really, really want to congratulate them for their work in this regard. It's an emerging area. It's not an area that a lot of people know about. It's not a very sexy, but it's a golden area. And I think they have done a lot to allow us as legislators to fully understand and for us to be able to talk to Jamaicans about it. So congratulations and thank you. Mr. President, as the Minister mentioned, this bill went to the Joint Select Committee, and she also mentioned that a 2017 bill based on the number of proposed amendments was really scrapped, and a new bill, 2020 bill, came about. And I wanted to say one thing at the risk of being a little controversial, and I hope it's not taken that way. But having attended the Joint Select Committee, it underscores one thing in my mind. and it is the importance of the Joint Select Committee. It serves a purpose. In this committee, we had over 20 presentations from persons, not just institutions, not just large institutions, Senator Gale, but individuals. You had persons travel from all across Jamaica who came and let their voices be heard. The committee listened, the committee took some in consideration, the committee asked questions, and we may not always agree. But I believe that the good thing about this bill is that anyone who wanted to make a contribution had the opportunity to do that. And at the end of the day, even if their views weren't taken on board, they were listened to and they were given the respect and the acknowledgement. And it underscores in my mind the importance of Joint Select Committee and for good governance. So I just wanted to point that out. Mr. President, the minister, and quite rightly so, went through the bill, and so there's not much more for me to say more than that. It is a game-changing piece of legislation. There is no doubt that personal information, Minister, you said a new gold, I want to go a step further and say it's a new platinum. It really is. I mean, people pay big money for personal information. And this piece of legislation is really putting in place, once and for all, a strategic, well thought out framework on how we're going to treat people's personal information. And it comes at a critical time. It comes at a critical time where cyber crime and hacking is at an all-time high. Just recently, for example, I know of a financial institution right here in Jamaica that stated publicly that it was a victim of hacking. I also know, but I can only speak with authority about one, very recently in March. I also know that there's another financial institution that shared that there has been some inadvertent sharing of clients' or customers' information with other customers. And though they notified customers, they took steps to correct it. The fact is that with this bill, it sets out how you treat with that now. So it is not left to the individual in a subjective way to treat with it. But there is now a law in place that tells you how to treat with it. And I want to go further, because not just is there a law, but there will also be enforcement. There are committees in place that will treat with it. And so I fully support that initiative. Mr. President, there are several things, but there was one thing in particular that occupied the minds of the committee, and it has to do with MSMEs, the small, medium enterprises, and how this new venture or this new framework is going to impact on small, medium-sized enterprises. And we could not dismiss that concern. And I'm very happy that there are provisions in the bill that allows the minister, through consultation with the commissioner, to make exemptions in those cases. And this is something I think is one of the positive things coming out of consultation, but also coming in the bill, which I think is going to benefit small and medium-sized enterprises. And it even becomes more important now in light of COVID. And I say that because small enterprises are becoming smaller. But also what you find is that a lot of individuals are now becoming entrepreneurs because they have to turn them hand and make fashion due to COVID. So for example, I have gotten a plethora of text messages. You want something to be picked up, call this place. Places that never before existed. So you have bearer online now who can do your things and you can stay home but you have to pay by credit card. Yeah. You gotta pay by credit card, so you gotta have your information. So you have the curbside pickup. Yes. So this piece of legislation becomes even more important today than it was in 2017 or 2018 when we started, because of what has happened and because of how we have to treat people's information And because more and more persons, not just 5 or 6 or 7 individuals forming a company, but the one man doing him thing. And the one man is so advanced and sophisticated, and quite rightly so, that him not deal with hard cash. He deals with the digital economy. So him having machines, so him can swipe him credit card, and he's not medals. What do you call that one? The point of sale, yes. And so that thing becomes, it becomes more important that we protect personal information, and not just protect, but there is a framework in place on how we treat with the information that we have collected. Again, I'm very pleased about the provision, the exemptions for NGO, for charities, for churches, because again, that was something that was spoken about. And political parties, yes. But that was something that, and the trade union, Senator Gale, yes, that in fact came up, because it is something that we addressed our minds to, and not only because of the financial implication in having a data protection officer or having a data controller, but because of the fact that of what they do, right? And so I'm very pleased to see how it is captured in this piece of legislation. I'm winding down, Mr. President, but I have to touch on something which Senator Morgan spoke about several times, and I know he was very passionate. In fact, I think at one point I'm like, hey, Robert, take it easy, you know? But it was good, and that has to do with the issue of consent. Now, the bill provides that consent can't just be implied anymore, because a lot of prior to now, we have a lot of implied consent. So you do something, and you give information, so you're getting some text messages, you're getting some email. But what the bill provides for now is that consent is not about being implied. Consent has to be informed consent. So you have to be told what your information is going to be used for, and not just partially, but in full detail, so you can make an informed decision, yes? And I think that is good. The other thing about consent is that it must be expressed. We can't just assume that Senator Gale has consented, but he has to expressly consent to the use of his information and the manner in which his information must be used. And I think that is commendable. But the thing now, which you probably want to call the Robert Morgan clause, is that and I remember he was sitting, actually I think he was sitting right where you're sitting, Senator Gale, when he spoke about it, is that if a man decides that he doesn't want to consent, you can't deny him service. Hence Robert clause, because he was very insistent that you must ensure that in a situation where someone decides that they do not wish to receive information, what you call marketing information, then they ought not to be denied services. And I think that is something that is commendable, and that is something I'm very pleased about, and I call it a Robert clause. Enjoy it, Robert, enjoy it. Mr. President, the other thing that finds much favor with me is the establishment of the oversight body. This was not a provision that was in the original draft, and it came about because there is, and quite rightly so, a genuine concern that so much power, when you go through the bill, you realize that there's so much power concentrated in this one individual. And who regulates what he does? Who monitors? Who oversees what he does to ensure? And it's human, and people will have tendency to use information. And to protect the office, it was recommended and accepted by the committee that an oversight body should be established. And that is something that finds favor with me, and I think that is also one of the good things and the lasting things about the bill. And as I wind down, because as I said, I did pay it forward, and cognizant of the fact that colleagues have been in here for a while, and the technical nature of the bill, I will not be long, but I want to close off on a note, Minister and Senator Morgan, and it has to do with public education. This process has perhaps been one of the better process in terms of governance, in terms of the persons we interface with, in terms of the widespread nature. And again, you have to commend the ministry for taking that lead. Let us not drop the ball after this becomes law. What is required is an ongoing public education. And I'm saying public education, not public relations, because there's a difference.
Fundamental difference.
There is a difference. We have to undertake a public education so that every jackman understands what this means for them. Because it is not going to be business as usual. And there are real penalties. We have to go, you know, and when I talk about public education, Senator Sinclair, I'm not talking about having a meeting at Kingston at one of the nice hotels. I'm talking about us doing what we did, what was done in the initial stages of going into Montego Bay, of meeting, yes man, a road show, like what the company's office does. We need to go to the people, touch flesh, and let them know, not in any fancy, because there's a big fancy word in here, Minister, that like you, I struggle to pronounce. Not them fancy words, but very simple words that anybody, the man in Southfield, am I correct?
Yes,
Southfield?
Senator Skeffer, can you stop interrupting the speaker, please?
So that the farmer in Barber Green planting his melon and in Skellion will understand what it means. And so that is a kind of public education that I'm calling for. And I believe that with the kind of dedication that has gone and commitment that has gone into preparing this bill, if we use that in the public education and the implementation, then Jamaica gone miles ahead. We have our agreement with CARIFORUM, and I think this will set us apart. It will play a very important role in our digital economy, but certainly how people see us as a country, desirous, particularly after COVID, of advancing our economy. And with that, Mr. President, I thank the technical team for their work. I did not mention CPC and AG, but they were at every meeting. I do want to thank the technical team, and I believe that this is a good piece of legislation that has my complete support. Thank you, Mr. President.
The opposition participated well at this.
And Karen said too.
Thank you, Senator Binns, and I see that you had difficulty controlling people to your left. The left is always hard to control. Senator Robert Nestor.
Mr. President, colleagues, I want to start by, as the newest member of the Senate, say that this was my first joint select committee, and I don't think that I could have asked for a better opportunity, not just in terms of the law that we were seeking to contemplate, but also the diversity of opinions from both sides and the support that we received from our technocrats, particularly the Ministry of Science and Technology, the CPC, the Attorney General's Department, the Office of the Parliamentary Council. My colleagues, and I praise my colleagues every day, but I want to take a special opportunity to praise those on the other side who we had our debates. I am Senator Fraser Binns, I am Member Golding, interventions by leader of opposition business. And I will say to you that in all the years I have from being a journalist, watching and listening to Parliament, I felt happy to be a part of that process, a part of the consultation. It was not acrimonious, it was more collaborative and engaging. So I want to just say, are you going to be that guy? But part of the reason why I'm so happy to have been a part of this committee is that I believe that the Data Protection Act is probably the most important law that we have passed as a country in the last probably 10 to 15 years. Why do I say that? And thanks to Leader of Government Business, Senator Johnson Smith, for her very detailed appraisal of the bill. I do not seek to compete with you, but there are some issues that... Why do I say that, Senator? And congratulations on your awards, sir. I think it is well deserved. From the first day I met you at Butcher's. At where? Butcher's. You wouldn't understand that language, my friend. Met you at Butcher's in 2001. Yes. It used to be called Culturia on Taylor Hall. And as someone who has gone through the struggle and risen above your struggle and become a symbol of triumph over adversity, I think I could not stand here today without acknowledging the hard work that you have put in. I've seen some of the hard work you have put in and commend you and say, well deserved, sir. Well deserved. Why do I say that this bill, this law that we have passed, and we're now debating, it was passed in the lower house, we're now debating it, is the most important in the last 15 years? It is probably the only bill that touches every single Jamaican at their most personal level. It touches women, men, children, the healthy, the sick, persons with different abilities. Because your yes, every individual, your personal information is what defines you in a digital society. Your personal data is what determines your existence or proves your existence in a digital society. And unless there is a framework where that information can be governed and protected, countries like Jamaica are left vulnerable to all sorts of challenges that exist in the world. The issue of data protection has been at the forefront of considerations in our society for the past couple of years. And data is now a commodity. Your data is being traded as we speak by corporations, countries, and individuals for money. The monetization of data, Mr. President, is big business and forms the bedrock of many modern companies, such as Facebook. Your information, Mr. President, is for sale to the highest bidder. And as uncomfortable as that might sound, that is the reality of the world we live in, and sometimes it is even being traded for free. The New York Times reports, Mr. President, recently that Facebook allowed Microsoft's search engine, Bing, to access the names of virtually all Facebook users and friends without their consent. It gave Netflix and Spotify the ability to read your Facebook private messages. Yes, it was reported in the New York Times. Amazon was able to obtain users' name and contact information through their friends. Through their friends. And Amazon let Yahoo view streams of friends' posts as recently as last summer. despite public statement that it has stopped sharing such information. Mr. President, your data is a commodity being traded for cents on the dollar and sometimes even less. In many cases, it is legal sharing because when you sign that long privacy agreement that they send you, that takes a week and has fine print in it and you never read it, you give away your rights. So in many cases it is legal, but the amazing thing about our modern world is that a lot of the data sharing that is taking place is illegal. Let's look at some information. In 2015, 13.1 million individuals in the United States were impacted by identity theft, and the cost was $15.5 billion. In 2017, 16.7 individuals were impacted by identity theft, and the cost in terms of dollar amount stolen was $16.8 billion. Let's look at some other figures. In October 2013, 153 million user passwords were stolen from Adobe. May 2014, 145 million passwords and personal data was stolen from eBay. Marriott International lost 500 million customer personal information between 2014 and 2018. 500 million people over 4 years. When you sign up to Marriott, they want your name, your credit card number, your address, your phone number, next of kin, purpose for visit. Somebody in some far-flung country. And who is visiting it? Well, that wouldn't apply to me. A hacker now has that information. Mr. President, digital innovations are reshaping the society and the world we live in and impact our economic, culture, communities, and our individual lives. The fact is, Mr. President, as we move towards a digital society, the impacts do not only occur at the centers of digital innovation, which is probably America, Europe, and so forth, but are also concentrated in small island developing states, who in many cases have been rendered vulnerable as their digital innovation has not kept pace with that of innovation centers like Silicon Valley and so on. It means that societies like Jamaica must innovate in order to survive and protect its citizens. We must create robust legislation and regulatory frameworks to ensure that our citizens are protected in a digital society. And we must do all we can as well to benefit from a digital society, but at the same time protect ourselves from its challenges. Mr. President, I don't want to bore you, but I'm gonna have to use a lot of numbers in my short presentation. In 2017, no man, and she was so generous to leave some for me. Mr. President, in 2017, a little bit over 50% of Jamaicans had internet access, which moved from about 27.7 in 2010. There are over 1 million smartphone users in Jamaica right now. And if you look around you right now, you see most of us in here have a smartphone. It means that not only are Jamaicans engaging with the internet, but they're also engaging with the mobile internet. What that means is that instead of a static desktop where you go and provide it information and it gives you information, your smartphone is now constantly with you, collecting data about your everyday life. 64% of Jamaicans, Mr. President, are on Facebook. That's about above 1.5 million people. About 40% are on Instagram, and a little below 10% are on Twitter. Mr. President, Facebook has your name, your date of birth, your address, in many cases your phone number, pictures, and in some cases family members' information, and other information triangulated based on the friends you have. Let's for a minute contemplate if Facebook got hacked and the private data of 1.5 million Jamaicans ended up with some Russian hacker who is selling credit cards. Think about the impact that will have on the economy. The Survey of Living Conditions says that 43% of Jamaicans in 2008 benefited from remittances. 43% of Jamaican households. In order to collect a remittance, you need to tell the company your name, your address, your occupation, maybe your contact number and email address. You may have to present them with an ID. Mr. President, I ask the question, before this law comes into force, who governs the use and management of all that data? Who? I used to be afraid to go to remittance because every time they used to ask me for my lungs, I was afraid to write it down. Your lungs. They want everything. Your lungs. No, but it's still because of the current challenges that we are faced with scamming. Remittance companies have been forced to even be more intrusive into your personal life. But while we were allowing companies to be intrusive in our personal life, we had to be spending the time now and thankfully creating this law that can actually protect us when they take that information from us. Mr. President, when you sign a form to access services at a bank, with the government, your doctor's office, who owns that data and how is that data being used? Is it being shared with anyone? And I must acknowledge that some businesses have very good data protection regimes. But we cannot leave our fate to the discretion of man. And I mean, I could go on and talk about data theft as much as possible, because in the United States, cybercrime and identity theft is big business. 780,000 records were lost in 2017, according to McAfee. 24,000 malicious mobile apps are blocked daily, according to Symantec. Cyber security ventures predict cybercrime damages will cost the world $6 trillion annually by 2021, up from $3 trillion in 2015. Here in Jamaica, Mr. President, as Senator Binns noted, there have been several incidents of major companies who have either inadvertently shared people's private information or been hacked. A very large bank recently was shut down because hackers took over their systems. The Gleaner reports that Jamaica lost in excess of $12 billion to cybercrime in 2016 alone. And given evidence that Eastern European hackers are among those cashing in on this lucrative industry, Director of MOCA described cybercrime as the most nefarious of the challenges that law enforcement officials will face going forward. Mr. President, one of the more important clauses of this bill and of this law is that it gives data subjects control over their information. Finally, Jamaicans have right in law to their data, and I think that's something that the Parliament must commend itself on. If you look at one of the more important clauses in this bill, I think it was clause 6, where the individual has the right of access to its personal data. So the individual now can write to a data controller based on the rules and regulations in this law and demand access to the data that they have on them and also get knowledge of what this data is being used for.
Free of charge.
You have to pay a little fee in some cases. But what is important about this bill, and Senator Morris, I think that in the deliberations of the committee, one of the considerations that we thought about was a lot of these people, when they give you information, they don't give it to you for you to use. As a matter of fact, a lot of them don't give you information for people with different abilities can use. So a consideration in this bill was, how is it that persons with different abilities will be able to navigate the data that they're given? Persons who are maybe hearing impaired, persons who are maybe sight impaired. And that is something that I'm very happy that the bill considered, and the persons on the committee and the technocrats all came together and said this is something that is very important. So the right of access, which I consider the right of access, which I consider access to your data and control of your data, I see it as a fundamental right. Your data is your person, and the right to privacy is secured under our charter and our constitution. So when there was a debate in the committee and when there was a debate in the public as to whether or not the burden should be transferred to the consumer rather than the corporate, I think a majority of us on the committee said that the individual must have the right to their data, and the onus cannot be on the individual to ensure that their data is protected when they hand it to someone, which is where clause 9 and 10, particularly clause 10, came aboard. And I won't take credit for it because, and many people didn't know that part of the reason why I enjoyed being on the committee so much is that one of my teachers who taught me law sat across. I won't tell you which one. So I had to be on my best behavior and P's and Q's because I didn't want to embarrass her. I was! But clause 10.
Thanks for that data.
And we debated clause 10 for weeks. The technocrats were very patient with us and with me as we constantly said to them, how can we balance the important right of citizens to protect their information and their right to privacy while at the same time allowing businesses to effectively function? And I think clause 10 in this law has satisfied that requirement. A big part of the data protection is the ability of persons to control how their data is used. We all have been having situations where we are bombarded with marketing, and in some cases you wonder, how did these people get my number? If you look in your phone right now in your text messages, you will see a long line of ads from various businesses who you never interacted with. In Jamaica, companies, and I will not call their names, have been taking information of their customers and sharing with other entities and making profit from the sharing of you've already paid for the service, you know. You paid for your phone, you paid for your data plan, it wasn't free. But then they take your data and they give it to someone else who now sells you information. The good thing about this law, and we use a lot of the information from the GDPR and particularly from South Africa to look at how they managed it. And now, instead of an opt-out regime where you have to go to the business and say, please don't send me no information, at the point of interaction, they have to clearly ask you, do you want us to sell you marketing information? How do we treat your data? And the good thing also is that they cannot tie your consent for marketing with your need for the service. It has to be a totally separate arrangement. So it's not a case where you will not get this discount unless you give us consent for marketing. The law now says that is not possible. And I'm very happy about it, because as a young person who is on social media, one of the biggest issues that people have is how do people get my number if you send me so much message? And that is something that I'm very happy that the law is dealing with. Mr. President, my position is that the data subject must in all cases be prominent in any consideration of their data, and the interest of business must be subordinate to that. The philosophy is that you own your data, and you are entitled to privacy as a right. No longer can anyone without permission bombard your device with marketing information that you may not wish to have. Service must not be denied because you refuse to sign up for marketing. There are other clauses in the bill, and I will not delay or tarry or go too in depth in them, but there are a few clauses in the bill that I really like. And one of them is something that we discussed in the committee a lot, and it's the whole issue of registration. Now, I am always a proponent of individual rights, because the individual is probably in a society the weakest component. They are vulnerable to the state, they are vulnerable to the community, they are vulnerable to state law enforcement, they are vulnerable to businesses. My view at the time was that I agree, small businesses must have some consideration or must be considered in relation to this law, so that so as to not place an onerous burden on them which may cause their businesses to collapse. But on the other hand, if I am an individual and I give my information to a doctor's office, all my medical information, they have it, and they do not maintain good data management practices, and somebody hacks that doctor's office, regardless of the size of the doctor's office, the impact on the individual is the impact on the individual. So the size of the business does not determine the size of the impact of the data breach on the individual. If somebody hacks and steals my identity and empties my bank account, it doesn't matter whether it is a large corporation or a small business. It is I, the individual, who is being impacted. And I think we have got a balance in this law that ensures that the individual rights are protected, while at the same time not placing too onerous a burden on small businesses in terms of acquiescing to the requirements of the Data Protection Act 2020. The other issue that I think I want to touch on, Mr. President, is the fact that we were very careful not to impact on the freedom of the press and freedom of artists and so on to do their jobs. Jamaica has been very fortunate that we are now number 6 on the World Press Freedom Index. And while I may be tempted as a member of this administration to take 100% credit for that as a representative of the government, the reality is that this position in terms of Jamaica's reputation internationally as a country that guards jealously the right of freedom of expression and the press is something that has been built up over many decades, transcending administrations, an ecosystem of freedoms where everyone in Jamaica understands that the media has a right to report what they need to report, and no government is going to interfere or fetter the right of the media. And I think we were very careful, despite commentary from certain stakeholders. We were very careful, and I think we got the right balance of ensuring that the media was able to do their jobs, but at the same time protecting the right to privacy of individuals. It doesn't mean that freedom of expression means that it must impact on my privacy. Freedom of the right to the press does not mean I lose my right to privacy. And while we respect freedom of the press has been demonstrated by our scores consistently, positive scores, even before this administration, globally Jamaica always was at a prominent position in terms of freedom of the press. So it's not a partisan commentary. And I think us as a Senate and even at the other place and as a society must commend ourselves for continuing to pass legislation that pays respects to the rights of privacy, the rights of freedom of expression and freedom of the press. And that's something that we should all be proud of. And I think we have found the balance here, especially literature and art. We have a very good, I mean, it's not as...
Mr. President.
Thank you. Thank you very much, Madam.
Mr. President, the time being 1:20, might the Senate be permitted to sit beyond 1:30 to complete the business of the day?
Members have heard the question. Those in favor? Against? And Madam Leader, the Speaker's time is just about expired.
What? In sync with 120? In sync with 120?
President, the Speaker's time having expired, may I ask that it be extended to allow him to conclude his presentation?
Those in favor? Against? This is so enwrapped. We were.
Mr. President, it is very ironic that you're extending my time as I'm about to make this point, because my twin loves have always been media and art. And there's a relationship that exists, which I will not elaborate, outside of this place, where I was taught by a great man who has since passed, Cecil Cooper, about art and the importance of art, not just as enjoyment, but art as political commentary, art as resistance, and art as revolution. And I think Jamaica has had a rich history of artists who have demonstrated how to use art as a means of speaking out against certain things within the society, as a means about speaking out against injustice and promoting particular ideals. And one of the things in this bill, in this law, is protecting journalism, protecting the rights of writers. You yourself, Mr. President, is very close to the art community, artistic community, and protecting the rights of artists to free expression. It does not impinge on their right to free expression, and that is something that I think we should all be proud of. Mr. President, I do not wish to delay much more other than to make a general point about this law. As we move towards a digital society, our society will be bombarded by challenges related to data protection, and how do we protect the rights of Jamaicans. I am not someone who questions the court, so I'm guided by the recent judgment of the Court of Appeal in relation to the National Identification System. And one of the most important points that the court made is the importance of securing. How do you secure the data of persons who are going to be engaged in the system? And that is not something that we as a parliament or we as a people can take for granted, especially recognizing the significant risks that exist within the world today, where data is now becoming a commodity that is being traded and is being hacked, and people are scamming credit cards and so forth. So I think that as we move forward, and the question that the opposition kept asking was, why pass NIDS before the DPA? That question has now been answered. And I suspect, based on the current approach of the government, recognizing the opinion and judgment of the court, recognizing the fundamental importance of Jamaica having a robust national identification system, not just for the benefit of the state, but for the benefit of every single Jamaican. And I'm not going to challenge you, leader, but I will say this. And the court has ruled, and I'm not going to even question anything that the court has done. The government has accepted the ruling. But I want to emphasize why I am so passionate about a national identification system, and why I am very happy that we now have a Data Protection Act that will make a national identification system more robust and effective. Think about this. The first question we must ask is, in a global world that is based on zeros and ones, that is based not on your own personal credibility, but based on demonstrating to somebody that you will never see over an internet connection, in a transaction, who you are, how do you verify that identity? Especially if it is stolen. What is the backstop? The second question is, if it is stolen, and you just took out a mortgage in Florida that you do not know anything about, how do you prove to people who have no idea who you are, digitally, that you are who you are?
You're not the one who did that.
So at the beginning of my speech, I spoke about a robust framework of data protection that is not just about legislation, but also regulation. And I want to associate myself with Senator Fraser Binns' position that along with that must also be robust public education. Because in order for Jamaica to be competitive internationally, in order for Jamaica to have an edge, how we manage our data and how we secure the identity of every single Jamaican and can be able to verify it is one of the most important cornerstones in this edifice that we're trying to create called a modern country. And I say from myself, and I suspect that I can speak on behalf of the government, that our desire is not to diminish the views of others as it relates to legislation that we're seeking to put forward, especially as it relates to needs and now the DPA, but a recognition of the urgency, of protecting the identities of every single Jamaican from threats that in many cases they do not even know exist. And if we can, as demonstrated through the process of the Data Protection Act, maintain the same approach, leader, I suspect that both of us, including the stakeholders, including the technocrats, and citizens in general, can be watching in a couple months from now when we're debating another bill to say this is another symbol of cooperation between the government and the opposition along with stakeholders for the betterment of the country. Mr. President, thank you very much.
Mr. President, I understand that there are still one or two persons who did not sit on the committee who wish to share their views on the bill. And therefore, we have agreed that we will suspend the debate and continue it at the next sitting. And Mr. President, I do believe that that fine presentation by Senator Morgan does provide us with a high point on which to end a debate on a very technical bill today.
Is that the debate be suspended for a date to be fixed?
Yes.
So that is the question. Those in favor?
Aye.
Against? And may I just say, Madam, that I listened to, although I wasn't in the chamber, I listened to the complete presentation by Senator Morgan and the presentation by Senator Fraser-Binns, and it all goes well for future debates on this bill in particular, but generally speaking. So the quality of the debate this morning was well worth it. So I understand that.
President, just before we break, I just want to urge all of us as we leave here. There are reports of disturbance in sections of the corporate area, so I urge us to be safe and to plot our routes as we go.
Thank you very much. Leader?
Thank you, Mr. President. Mr. President, I also ask that we recommit notices of motion given orally.
Thank you. The question is that the agenda item notices of motions given orally be recommitted. In favor? Against? Minister?
Thank you, Mr. President. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move, be it resolved with reference to the resolution passed by this Honourable Senate on the 7th day of February 2020, agreeing that the composition of all committees of the Senate remain unchanged in this session of Parliament, except by approved resolution of this Senate, that 1. Senator the Honourable Matthew Samuda be replaced by Senator Ransford Braham as Chairman of the Senate Regulations Committee, and notwithstanding Standing Order 66.3, Senator the Honourable Matthew Samuda remain a member of this committee, and 2. That Senator Robert Nestor Morgan be removed from the following committees: the Senate Standing Orders Committee and the Senate Regulations Committee. I do not have the replacement names at this time, Mr. President, but we will bring them in due course. But, Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of standing orders to allow me to take the motion, notice of which I have just given.
Mr. President.
Thank you very much.
Mr. President, I wondered whether we could move a resolution for Senator Morgan to go back to the Data Protection Committee.
Yes. So you want to recommit notice of, we did that. So you have given that. Yes, okay, go ahead, please.
Mr. President, might I ask that standing orders be suspended to allow me to take the motion, notice of which I have just given?
Thank you very much. Members have heard the question. Those in favor?
Aye.
Against?
Mr. President, may I ask for approval of the motion of which I have just given notice?
Well, there seems to be some dissent, but I think the majority may have it. Those in favor? Against? The majority have it.
Thank you, Mr. President. It's not intended to do any further business today. Might the Senate be adjourned for a date to be fixed?
Thank you very much. The question has been put. Those in favor? Against? This Honourable Senate now stands adjourned to be for a date to be fixed. Mr. Horton, the Senate now stands adjourned for a date to be fixed.
This is iRoy,